this displacement of Kosovo Albanians been the consequence of NATO bombing or of fighting between the KLA and Serbian forces or the like, it is not apparent why Kosovo Albanian refugees would be stripped of their identification documents. Telling in this respect is the evidence of General Karol John Drewienkowicz and Colonel Richard Chiedlinski, two British officers who observed MUP officers burning tens of thousands of identification documents in a courtyard adjacent to the MUP building in Pristine, on 12 and 13 June 1999, which is just before the cessation of hostilities in Kosovo and when Serbian forces were about to leave Kosovo. As indicated, the Chamber is satisfied that the offences of deportation and forcible transfer have been established with respect to some 60 locations listed in the written judgment. These were spread over 13 municipalities charged in the indictment. While over 800,000 Kosovo Albanians left Kosovo in the period relevant to the indictment, this trial is only concerned with those from the villages, towns and other locations specified in the indictment. The evidence is not sufficient to enable reliable findings as to the numbers of Kosovo Albanians proved to have been deported from these specific locations to Albania and Macedonia, or in some cases to Montenegro, between the 24th of March 1999 and the 20th of June 1999. It can be concluded from the evidence that this number was at least 200,000. However, this estimate is incomplete and very conservative, and the true figure is likely to be very much higher. The indictment also alleges the criminal responsibility of Vlastimir Đorđević for the murder of hundreds of Kosovo Albanians, including 840 persons known by name and specifically listed in the schedules of the indictment. The Chamber is satisfied that the charges of murder as alleged in the indictment have been proved with respect to the many locations in Kosovo specified in the judgment. In particular, the Chamber has found that not less than 724 Kosovo Albanians were murdered by Serbian forces, in most cases police. In the large majority of cases, the victims, including women and children, were civilians who were unarmed and not in any way participating in any form of armed conflict. I would emphasise that this trial is not concerned with members of the KLA killed in combat with Serbian forces. However, some of those murdered may have been members of the KLA, but when killed, they were prisoners of the Serbian forces, unarmed and unable to participate in any form of armed conflict. No attempt was made to identify or arrest individuals for the purpose of investigation or trial as terrorists or suspected terrorists. The Chamber notes also that it is clear from the evidence that the murder offences charged in the indictment are merely examples and by no means exhaustive of the crimes committed by Serbian forces, especially police, against the Kosovo Albanian population in the course of the widespread and systematic attack referred to. By way of three examples, on the 26th of March 1999, approximately 114 men and boys, the male inhabitants of a village in the Rahovac or Rahovec municipality, were forced by police into a barn in the village. One of the men was disabled. His wheelchair was used by the police to block an entrance door. When all the men and boys were inside the barn, the police shot them with automatic rifles. The police then poured incendiary liquid over the bodies, placed maize on top of them, and set the barn on fire. As another example, not less than 45 members of one family were killed in Suvareca town by police on 26th of March 1999. Some were killed at their homes. An elderly couple was shot as they tried to flee from the houses. Then 35 members of the family, mainly women and young children, sought refuge in a nearby cafe. Police threw hand grenades inside the cafe and then opened fire on them, killing 32 women and children. In another town, Podujeva, in the courtyard of their house, Serbian forces lined up and shot 19 women and children, members of two families. Of these, 14 women and children were killed. While 5 of the children survived the incident, they sustained severe injuries, many of them permanent. These examples demonstrate that the conduct was not part of a genuine police operation to locate and arrest terrorists. As detailed in the written judgment, the Chamber is also satisfied.
Si që shtjellohet në akt gjykim, dhoma gjithashtu është bindur se është provuar që krimet e transferimit të dhunshëm, dëbimit dhe vrasjes u kryen me synimin e diskriminimit të popullatës shqiptare e kosovare me bazën e përkatësisë së tyre etnike.
On the basis of their ethnicity, we have a technical problem. It's now been restored. We continue. The Chamber is also satisfied that the offence of persecutions by the deliberate destruction of mosques by Serbian forces has been established. The destruction of these mosques occurred pursuant to a campaign by Serbian forces which included the systematic damage and destruction of cultural monuments and Muslim sacred sites of the Kosovo Albanian population. While the Chamber has found that incidents of sexual assault have been established, no evidence has been presented that the perpetrators acted with intent to discriminate. Intent to discriminate is an essential element which must be proved. Therefore, the charge of persecutions committed through sexual assault has not been established. The accused did not personally commit any of the crimes charged. They were committed by Serbian forces, many of whom were police under his command. Nevertheless, it is alleged by the prosecution on several bases that the accused is criminally responsible for the commission of the crimes. In this summary, the Chamber will mention briefly three of these bases for criminal responsibility: joint criminal enterprise, aiding and abetting the crimes, and command responsibility. A primary allegation against the accused in the indictment is that he participated in a joint criminal enterprise, that is, a common plan which, as noted earlier, had the alleged purpose of changing the ethnic balance in Kosovo. This objective was to be achieved through criminal means, consisting of a widespread and systematic campaign of terror and violence against Kosovo Albanians, and which included the crimes charged. The accused denied that there was any such common plan formed by a group of persons which included the accused. The defence submits that where crimes were committed in Kosovo during the indictment period, these were the result of isolated incidents perpetrated by random individuals. As mentioned already, it is contended that any coordinated actions by the VJ and MUP in 1998 and 1999 were directed only at terrorist forces and so were legitimate under customary international law. The Chamber was not able to accept these arguments. While operations leading to the deaths of some Kosovo Albanians may have been conducted under the guise of anti-terrorist operations, and that may have been among the objectives, it is starkly clear from the evidence that these operations were not limited to members of the KLA. The nature of the crimes that have been established and the circumstances in which they were committed clearly demonstrates that the target of this campaign was the Kosovo Albanian population. In the finding of the Chamber, the operations were typically aimed at terrorising the Kosovo Albanian population in cities, towns and villages. This was achieved by a variety of means, including shelling of populated areas with heavy weapons, terrorising the people there by threats, violence and killings, setting on fire Kosovo Albanian civilian property, and the destruction of villages. The civilian population, or those of it who were not killed, in many cases were forced to leave their homes, villages or towns, in most cases to join others to be transported across a nearby border or to join columns of displaced persons directed by Serbian forces across the borders. The scale and coordination of the actions of Serb forces confirms that a common plan existed. The common plan required the agreement and participation of political leaders of the FRY and Serbia, the leadership of the VJ, including the relevant corps in Kosovo, and the leadership of the MUP, including its staff in Kosovo. For reasons set out in the written judgment, the Chamber is satisfied that persons in these roles acted in unison to effect the joint criminal enterprise. Among the core members of this group of persons, the political component included Slobodan Milosevic, the President of the Federal Republic of Yugoslavia, and Nikola Sinovic, the Deputy Prime Minister of the FRY and responsible for Kosovo. The MUP membership of the Joint Criminal Enterprise included Vlajko Stojiljković, Minister of the Interior, the accused Vladimir Đorđević, Chief of the RJB, Radomir Marković, Chief of the State Security Department, and Sreten Lukic, Head of the MUP staff for Kosovo.